Welcome students. So today we are going to talk and discuss about the Indian Polity test 11. Okay, in the UPSC daily answer writing program, this is the 11th test. Okay, that we are going to discuss. In the previous lecture we also discussed the already 10 tests. Okay, now this is the 11th test that we are going to discuss. There are 10 questions here. It is a short test. Okay, 10 questions here, and here also what we are basically discussing, what is the demand of the question. Like in the 10th test that we have discussed, we have also discussed what is the demand. First you have to understand the demand, and then only you are able to write. So while reading the question only you have to understand the demand, like what is specifically asked in this particular question. So here also we are going to discuss it question by question. We will read the question, we will understand what is the demand of the question. After understanding the demand of question, then we are going to see like how you are fulfilling the demand of the question. So first question, it is asking about examine the significance of the basic structure doctrine in preserving the integrity of the Indian Constitution and discuss the challenges faced in upholding its doctrine. See, two things are specifically asked in this question. First, the question is asking about the significance of the basic structure. See, basic structure has been given in 1973 Keshavananda Bharati judgment. That is your introduction. Okay, it is given here. Keshavananda Bharati judgment, Supreme Court judgment. Here it is specifically talking about the basic structure. And the question is specifically asking the significance and the challenges faced in upholding its doctrine. So two things has specifically been asked. First, we will talk about the significance of the basic structure. Okay, why it is important. See, it is important to protect against the authoritarianism. Now we know the basic structure, right? That these are something which where you cannot change the things. Okay, this is just like a soul of the Indian Constitution. If the Supreme Court thinks that this particular thing should not be changed, it will change the meaning of the Constitution, the provisions of the Constitution. Then the Supreme Court can ask not to change the thing considering as a basic structure. Okay, so this is important so that government do not use its power or do not misuse its power to just uphold its own authority on the cost of public welfare. Okay, this should not happen. So it's prevent the misuse of amendment process by any ruling majority. Then it preserves the constitutional supremacy, that constitution is supreme, no other authority is supreme than the constitution. Because basic structure is provision has been made to protect the constitution only. Then it is also judicial safeguard. It provides Supreme Court a tool to check the arbitrary constitutional amendments. So judicial safeguards also. Maintains unity and the integrity. It prevents fragmentation by safeguarding the federalism and the national integrity. Okay, maintains unity and integrity because it says that see, unity and integrity is the basic structure of Indian Constitution. It ensures the balance between the flexibility and the stability. So basic structure does not mean that the amendments are not allowed. Of course they are allowed. But core constitutional ethos will also be protected. They will never be harmed. That is why basic structure is particularly significant. But what are the different challenges in maintaining the basic structure? First thing is ambiguity in the definition. There is no definition of the basic structure. Supreme Court has not given any definition. Then judicial subjectivity. Heavy reliance on the judicial interpretation. Supreme Court can say anything as a basic structure and you cannot do anything. Tensions between the legislature and the judiciary because it prevents the legislative power of making any amendments. And it gives the power has been shifted to judiciary. More powers has been given to the judiciary. Implementation hurdles. Okay, the vague boundaries complicate the legal process in constitutional matters. Whenever any amendment has been made, first it has to go through the basic structure then. And actually it reducing the powers or it reducing the difference, separation of a power between the judiciary and the legislation, that leads to the implementation hurdles. Political resistance, because there are multiple rulings, politically sensitive rulings has been given with respect to the basic structure, that leads to the executive criticism. And there is a evolving social norms, new values. For example, digital privacy need recognition in this framework, but basic structure has not given such evolving things. Still the recognition under this concept, basic structure concept. Okay, so these are actually the challenges in implementation of this basic structure. Okay, and of course, here to make the basic structure effectively, it is important that judiciary first define the basic structure, and even by the constitutional amendment we can define what is the basic structure, and this has to be done. The Supreme Court should ensure restraint so that basic structure should not lead to any kind of a judicial overreach. Second question. What the second question is saying? It is saying that critically examine the challenges and the prospect associated with the implementation of the Uniform Civil Code. Uniform Civil Code is mentioned in Article 44 of the Indian Constitution. Uniform Civil Code, it is about promoting national integration, gender justice and the equality. Because it is about marriages, it is about the diversity, it is about the inheritance, it is about the adoption. So many things are there in the Uniform Civil Code that will be applicable to all the religions. Okay, that relates to social integration also. So there are arguments which are in favor and there are arguments which are not in favor of the UCC Uniform Civil Code. So that we have to see. First, what are the arguments that are in favor of the Uniform Civil Code? That is, it promotes equality and the gender justice. Because there are so many discriminatory practices against the women going on in different religions. For example, triple talaq. Such practices will be abolished. Ensure national integration, because this will be applicable to all the citizens. Doesn't matter which religions they are belonging to. It upholds the fundamental rights of the people, particularly that of women. It ensures right to equality between men and women. Okay, that is important. It simplifies the legal system, because there are different religions and different religions has their own legal systems. Now this will be simplified if we have the Uniform Civil Code. Then it fulfills the constitutional mandate. It achieves the goal set up by the Article 44 of the Constitution. Because in the Constitution itself, it is saying that there should be Uniform Civil Code. So if you are implementing it, you are of course performing the constitutional mandate, you are supporting the constitutional mandate. But what are the challenges in implementation of the Uniform Civil Code? See, this is important topic. So what are the challenges? Religious and the cultural sensitivities. That is actually a problematic thing. Religious and the cultural sensitivity. Okay, the minorities specifically are very sensitive regarding Uniform Civil Code. They think that it is attack on their religion. That is a problem. Then political resistance is always there. There are different political parties, particularly which is getting supported by the minorities. They are resisting it. Diversity of the customs and the practices. Different religions have their own different customs and the practices. They should not be touched. Okay. Of course, those customs and the tradition which are against the fundamental right, that can be made away with. But the cultural diversity should get protected. Judicial limitations, the judiciary, okay, supports the reforms, but it is up to the legislature to perform it. Okay. Fear of majoritarian bias. The minorities feel like that the majority bias will be here and this will be against them. So that is actually the challenges of the Uniform Civil Code implementation. Okay. So of course you have to move towards something new to implement this Uniform Civil Code. For example, you can take Goa as a model state where it is implemented successfully. That can be done. Judicial advocacy. Supreme Court in multiple cases has emphasized the need for Uniform Civil Code. So judiciary can perform better role here, implementation of Uniform Civil Code. Gradual reform approach. Okay. Codification and the reforms within communities to build the consensus. It is important to build the consensus among communities. Only then it can be done. It is very important to literate people legally and make the public aware. Public awareness is very, very important. Educate the citizens about the Uniform Civil Code. Make it acceptable for them. Only then it will be accepted. That is, the Uniform Civil Code is very, very important. But the thing is, first make people aware. Only then implement the UCC. Otherwise, that will not be helpful. Next, question 3 is about explain the constitutional provisions regarding the nomination of a member to the Rajya Sabha. Also discuss the significance of these nominated members within the Indian parliamentary system. Two things has been asked. First thing is very, very static. That it is specifically asking what are the different provisions in the constitution with respect to the nomination of a member in the Rajya Sabha. 12 members are nominated in the Rajya Sabha by the president. So you are asking about that. And second thing, it is asking about the significance. Why is nominating members is significant. Okay, their benefits you have to write down here. So first here, constitutional provisions with respect to the nominated members. What are the provisions? Okay, there is Article 18(1) and Article 83 of the Indian Constitution. It says that Rajya Sabha can have 250 members, but 12 are nominated by the president. Okay, then eminence in the fields of literature, science, art and social service. These people will be nominated from the four fields. Process of nomination. What is the process? The president nominates member based on distinguished contribution in the respective field. And it is done on the advice of the Council of Ministers, because president works on the advice of the Council of Ministers. Okay, that is how the Rajya Sabha composition is there. Elected members here 238, nominated members are 12 here. Okay, Then what is the significance? It is asking the significance of the nominated member. Why it is important? First thing is promoting the expert participation, because the nominated people are expert people. So expert participation is there. That is why this is important. Then representation of unrepresented fields. There are many fields which are not represented in the legislature. For example, science, literature, social service. These fields get representation. These are not represented. Encouraging non-political perspective. See, most of the people, MPs they are political people. So they only give the political perspective. These nominated people don't give the political perspective. That is why they are important. Preserving the constitutional values. Eminent personalities, of course, uphold the dignity and the decorum of the parliamentary proceedings. So that is why they are protecting the constitutional values in the parliament. Filling knowledge gaps in debates. See, these people are from the expert field. So when there is any things which is getting discussed with respect to their field, they fill up the knowledge gap, because the members may not have the knowledge about it, but the expert person has the knowledge about it. That is why these people are very, very important. Okay. This nomination is very, very required, because currently the nomination has been done by the president. Okay, here Ujjwal Nikam from the Maharashtra, an expert from the legal field, has been nominated to the Rajya Sabha. Okay, so here he can give the legal opinion to the government whenever required in formulating any laws in Rajya Sabha. That is why these nominated people are very, very important. Then, next question. What is meant by delimitation? Okay, then in your opinion, is it time for a fresh delimitation of the parliamentary constituencies in India? Justify your answer. Okay, delimitation. What is delimitation? It is asking first what is delimitation, and it is saying that whether it is required right now. Okay, so you have to write why it is considered required right now, but what are the challenges in implementing it. Okay, delimitation तो होगा इंडिया में, because 2026 तक हमने delimitation रोक के रखा है by the 84th Constitutional Amendment Act. 2026 तक, तो मतलब इसके बाद तो डिलिमिटेशन होना ही होना है. अभी सेंसस होगा, उसके बाद पॉसिबली डिलिमिटेशन होगा ही होगा आफ्टर 2026. So we have to do it. And why it is needed? That you have to write. First you have to write what is delimitation. So definition has been given here. That is redrawing of the boundaries of parliamentary and assembly constituencies based on the latest population data. You are redrawing the boundaries of assemblies or the constituencies, so that the population will be represented well in the assembly and the Lok Sabha. Authority who conduct the delimitation, that is conducted by the Delimitation Commission. Delimitation Commission is a statutory body which is established by the Parliament by Act. Okay, and the orders of the Delimitation Commission have the force of law. They are compulsory to be implemented. Okay, then is it time for delimitation? Yes, it is actually a time for delimitations, because we have waited a lot for delimitation. Last time successfully for whole India, it is done after 1971 census. So we need it right now. Okay. Population imbalances. Current constituencies are based on 2001 census. In 2001, only the boundaries of the constitutions has been changed. Overall numbers has not been changed. But the boundaries are also by the 2001 census. Unequal voter representation. In some state, there is a lot of voter representation. In some states like UP and Bihar, one MP is representing lakhs of people, so many lakhs of people, lack of representation. Urban-rural disparity is there. Okay, rapid urbanization has left some urban areas grossly underrepresented, because the huge population is there and limited number of MPs not represented. Federal equity concerns. It present freeze on seat allocation affects the equitable federal representation. Okay, some states has more population but less representation. Some state has less population, more representation. Okay, because there is a freeze till 2026 since 1971. That leads to the problem things. Okay, that is why it is required to have a delimitation. But of course, there are challenges. First, federal imbalance fix. Southern states thinks that they have controlled the population, so they will get less representation now. The states which are not control the population, they will get more representation. That can lead to federal imbalance risk. Political sensitivity. Okay, it has created a regional discontent, particularly among the south states. They think that okay, their good thing about population control will be negative for them now, because the representation is based on the population. Need for consensus. This is all this is required, of course. Okay, it required all party and the public consultation for the smooth implementation. That is why it is needed, of course, but of course there are limitations and you have to deal with the limitation first and only then you will be able to implement it. Next question is about the 73rd and the 74th Constitutional Amendment Act. What the question says? It says that despite more than 30 years since the enactment of 73rd and 74th Constitutional Amendment Act, the constitutional amendments, local governments in India remain weak and ineffective. It is saying that despite that much 73rd and 74th Constitutional Amendment Act, why the local government is weak? It is ineffective. It is asking you to examine the reasons why it is ineffective, and it is saying that okay, how the technology can empower the citizen and regenerate the grassroots governance. So technology, role of technology in the governance. So main question is about the reasons why the 73rd and 74th Constitutional Amendment Act is not properly implemented. First thing, there is a high state government control over devolution of the power. The 11th schedule of the Indian Constitution and the 12th schedule of Indian Constitution is about the dissolution of the power, and the state government has a complete control over it. These local governments do not have the finances. That is also a problematic thing. These local governments, whether rural or urban, they don't have their own civil servants. They are completely controlled by the central government or a state government. That is also the problematic thing. Okay, there is no fixed planning body, effective planning body. Though we have the district planning committee, but it is not that much effective. We need an effective planning committee which is not there at the state level. The local bodies and the urban bodies, they don't have proper infrastructure. For example, 25% of the villages where there is a Gram Panchayat, they don't have the Gram Panchayat buildings. That is a problem right now. Okay, so there are multiple issues with respect to the 73rd and 74th Constitution. Gram Sabhas are not conducted regularly. The Panchayat Pati syndrome is there, where the woman Sarpanch is not actually working. Her husband or any male person from her family is actually taking the decision. These are all the problems. Okay, that leads to creation of a many problem. So why? This is a problematic thing actually. So the next thing is how technology can empower the citizens and the regenerate grassroots governance. See, there are multiple schemes, like there is a BharatNet scheme. BharatNet scheme, where government is connecting all the Gram Panchayat by the internet connectivity. So there can be a e-governance because of that. The services can be provided faster. There will be less corruption. That is why this is required. The GIS technology can be used to check on the work which is implemented or the infrastructure that is implemented by the grassroots level. So this is required. Okay, the satellite technology can be used for land mapping, right? Land mapping satellite technology, which will help better to implement the schemes perfectly at the local level. The information and communication technology can be also used, okay, for transferring of the funds, keeping check on the funds, okay, so that the middleman can be skipped. E-banking can also be promoted there at the local level, so that the people get the benefits of the scheme which are implemented at the local level by the grassroots government institutions. So there are multiple technology things can be used so that the citizens get empowered and the grassroots level institutions get regenerated. And these two things are expected from you to write here. First thing about the lacuna, and second thing you have to write down which are the different the technologies which can be used for empowerment of the citizen at the grassroots level. Next question is about critically examine the major challenges faced by the Panchayat Raj institutes and the urban local bodies in effectively utilizing their power and the financial resources. Why they are not able to use their power and the financial resources? You have to write down the challenges, and then after, of course, you have to give the suggestion to how to overcome these challenges. So two things are specifically asked. I always told, always remember what is asked. First thing, challenges write down with respect to utilization of power and the financial resources by the Panchayat Raj institutions and urban local bodies. Second, give the suggestion to deal with the challenges. Okay, so here first we are writing about the challenges in utilization of the power and the finances. Let's understand the challenges. First, limited financial autonomy or dependence on the central government and the state government grants. They don't have much taxation power, so lack of financial autonomy. Incomplete devolution of the finance, I already told. 11 the constitutional amendment, 11 schedule and the 12th schedule. In the 11th schedule there are 29 subjects, in the 12th schedule there are 18 subjects, 18 functions, which are not devolved to the Panchayat Raj and the urban local bodies. Okay, very few functions has been given. Most of the functions state government keep itself, that is a problem. Political interference is of course always there because state government wants to control it. Okay, that is also a problematic thing. Capacity and the skill deficit. The people or the staff working there is actually lacks trained staff. They are not properly trained. There is a lack of modern infrastructure, technical expertise. Weak financial management is there. There is no proper budgeting, auditing, transparency, fund utilization. No. Then irregular elections and the delays. The elections are not conducted regularly. That is also the problematic thing. Okay, sometimes the elections are conducted after 5 years also. Even though there is a need to conduct the election every 5 years, that is actually a problematic thing. Okay, these are the challenges. Then how to deal with the challenges, that is important to know. There should be some way forward. Okay, so what can be done? What measures can be done for that? First, enhance the financial devolution. More and more finances should be given to the local bodies. Even second ARC, second Administrative Reforms Commission says that more finances should be given to the local bodies. That is important. Then full devolution of the function is important. These functions which are given in the 11th and the 12th schedule, this should be fully devolved at the local level. This is important. Strengthening of the State Finance Commission is important so that State Finance Commission is established every 5 years and the proper devolution of the finances will happen at the local level. Capacity building and the training is important at the representatives which are getting elected and the staff which is working in the local bodies. E-governance and the digital tools are important. Okay, promote digital platforms there for financial management, for service delivery. Corruption will be reduced and more services, better services will be provided to the citizens. Time bound local elections, this is very required. See, there is a constitutional guarantee to conduct the election at the 5 years, but this is not properly performed. This should be properly performed without the proper delays. This is important to do, and that will actually empower the local bodies. This is important to do. Next thing, see what is saying. Discuss the role of President of India as the guardian of the Constitution. So role of President of India has been asked. Because President of India is a guardian of Constitution, he has the responsibility to protect the Constitution. He even takes the oath to protect the Constitution. So discuss the role, his role. Second, examine the constitutional powers and the limitations imposed on the President within the India's parliamentary system. Limitations, examine the limitations and the powers. What are the constitutional powers the President has and what are the limitations on the power of the President? There are multiple limitations of the power of President that you have to write. First thing here, role of President as the protector of the Constitution. I told you, President is the protector of the Constitution. So what is his role? Executive head of the Union. Okay, so all the actions, executive actions are taken on the President name. So President ensures the working of the government happens according to the Constitution. Uphold constitutional provision. For example, suppose giving assent to the bills, he ensures that it is happening according to the Constitution. There are constitution provisions are upholding into the bill. Judicial appointment ensures that good judges are appointed here. The proper procedure is followed, ensuring judicial independence. Emergency powers, it is the President who has to ensure that these powers are not used unethically or unconstitutional manner. Role in the discretionary situation. For example, the President has discretionary power with respect to the during the hung assemblies. So it is the President who has to ensure that the constitutional principle are followed in forming the government during the hung assemblies. That is why it is called as the guardian of the Constitution. Then there are powers and there is a constitutional restraints on the President. So what are the powers and what are the constitutional restraints? Let's understand first. The power is executive powers are there. For example, appointment of the PM and the Council of Ministers and the Governor. This is the executive power he has. He has the legislative power with respect to the summoning or proroguing of the Parliament, dissolving of the Lok Sabha, giving assent to the bills. He has legislative power. Emergency power he has under Article 352, 356 and 360. Judicial power he has with respect to the appointment of the judges, providing pardons and reprieves under Article 72. Diplomatic powers he has because the international treaties and the agreements are signed by the name of the President. Time bound local elections, ensure free and regular elections without this is not required here. So he ensures that okay, all the institutions are working effectively here. Okay, so what are the different constitutional restrictions on the president? Okay, what are the restrictions? Just understand it. First, he is bound by the Council of Minister advice. He cannot take the decision independently. In most of the cases, he has to bound by the minister advice. No veto in money bill, no suspensive veto. He has to give the assent in the money bills. He can reject, of course, but no suspensive veto is there. Even in constitutional amendment bill, he not at all having the veto power. Discretion limited to the certain situation. For example, only when there is a hung parliament or there is a president rule. Nominal head, he is just a nominal head. The real power is always with the Prime Minister and the Council of Ministers. The judicial review of emergency proclamation, whenever he imposes the emergency, the Supreme Court can always be there to examine the validity of the president rule. So president powers are limited here. So of course he has the power, but always there are limitations. Okay, but president has the powers. Whenever it is required, president can use the power to ensure the constitution is followed. Next question. It is about the list of fundamental principles governing the Lok Adalats. What are the different principles in governing the Lok Adalat? Then, as an alternative dispute resolution mechanism, critically examine the significance in ensuring fair, accessible and uncomplicated justice in India. Okay, so first you are talking about the principles of Lok Adalat and then you are talking about the significance. The principles of Lok Adalat, when you are talking about here, Lok Adalat, first understand, these are the separately statutory courts which are established so that they can directly go to the people, interact with the people and solve their problems. So for that the principle of a Lok Adalat, it is important. The next thing it is talking about why they are significant. So both things you are talking about. Okay, so let's first understand here the principles of the Lok Adalat. First, voluntary participation. It says that okay, disputes are settled only when both the parties are willingly agreeing for settlement of the disputes. Then mutual settlement. The decisions are based on compromise and not litigation. This is important, that there should be compromise but there should not be any litigation with respect to the mutual settlement. Okay. Then binding nature of the awards. Lok Adalat decision is final and the binding. That is also the principle, basic principle. There is no requirement of the court fees. Flexibility in the procedure completely. Okay. We are not following the court procedures. We are following the normal procedures. Okay. Speedy and the informal process, because the complete process is informal. Like for example, judges are sitting together with the people. No lawyers are there. Okay, they are just settling the dispute with the discussion. So these things, simpling the procedure, this is very, very important. And access to justice for all, this is the main important basic principle with respect to the Lok Adalat. Okay, then what is the significance? First thing, the significance, it is cost effective. Okay, it is cost effective, means you don't require a court fee at all. If you already paid the court fee, you will get your court fee back. Then reduces the court backlog. Of course, there is a high pendency of the cases in the court. If Lok Adalat solving the issue, less pendency of the court. Time efficient resolution will be there. Okay, because settle disputes on the spot without lengthy procedure. कोई lengthy procedure नहीं है. उसी on the spot settlement of dispute हो जाता है, compromise किया जाता है फटाफट से. Okay, then promote social harmony. If issue is resolved, then there can be a harmony. If there are people are fighting with each other, if issue is not resolved, no social harmony. Simple logic. Okay. Ensure legal empowerment. Because in the remote and the rural areas where there is a lack of justice, Lok Adalat goes there and provide justice to the people. Legal recognition is there. The awards are final, binding and enforceable by the law. So once you adopted it, the award is accepted, you cannot approach anywhere, means the court judgment is settled there. That is the benefit, means the issue get resolved there automatically. That is the significance of the Lok Adalat here. Next, the last question here is examine how the Representation of People Act 1951 defines and deal with the corrupt practices and the electoral offences. So it is asking about how this act defines and deal with the corrupt practice and the electoral offices. Second thing, analyze the respective roles of the Election Commission of India and the judiciary in enforcing this provision. So you have to give the role of the Election Commission, then you have to give the role of the judiciary in enforcing the provisions which are given in 1951, which deals with the corrupt practices and the electoral offences. Okay, so here 1951, as per section 123, it defines the corrupt practices. What are the corrupt practices? Bribery. It is a corrupt practices. Having undue influence, interfering in the free conduct of the election with your influence, that is a problematic thing. Appeal on the grounds of religion, caste, community, language, that is also corrupt practice. Promotion of enmity between different groups. You are creating hate between different groups, that is a problematic thing. Publication of false settlements, false statements regarding a candidate personal character. So you are defaming a candidate, that is also problematic, that is also a corrupt practice. Hiring of the vehicles for free conveyance of the voters, that is also problematic thing. And booth capturing. Okay, right now there is not much incidence of the booth capturing, but yes, some places it still happen even after in the case of EVM. Okay, so these are all corrupt practices. Okay, so there are electoral offences has been given under the Representation of People Acts also. Okay, for example, false declaration of the nomination, that is the electoral offence. There is a fine or imprisonment for that. Then bribery, that is also a problematic thing. Okay, personalization at the polls, imprisonment up to 1 year. Booth capturing, imprisonment up to 2 years. These are electoral offences. So corrupt practice in electoral offences has been given. Now the question is asking about the role of election commission and the role of judiciary in ensuring that these principles or these provisions in Representation of People Act are followed well. Role of election commission is supervision of the election. Of course, ensuring model code of conduct is followed. This is done by the election commission. Monitoring and action taken against the model code of conduct violation. Election commission has a power. If someone is violating model code of conduct, to punish him. Then recommendation of the president for disqualification. If any person in the election commission think that should be disqualified under Representative People Act, it can recommend it to the president. President will disqualify. Appointing observers for free and fair polling. Observers are appointed at the polling booth for free and fair polling. Proposing election annulments in extreme cases to the judiciary. Okay. Then role of judiciary. What is the role of judiciary? Okay. Main role of judiciary is adjudication of the election petition. If there are if there is any petition with respect to any electoral offence, so judiciary adjudicate it. Then declare the election void. If the judiciary find that there are a lot of corrupt practices that happened, then it can declare the election void. It can even disqualify the candidate under Article 8A and 100 of the Representation of People Act if the candidate is imprisoned for any offence. Then interpretation of the legal provisions related to the elections. If any confusion with respect to the provisions given in Representation of People Act, so judiciary interprets it. And it's safeguarding the constitutional morality and the electoral integrity that judiciary ensures. If someone is harming the constitutional morality and electoral integrity, then judiciary can punish the person for doing that. So the Election Commission of India has also important role, and judiciary has also important role with respect to the fair continuation or completion of the elections. Here we have discussed the 10 questions, like what is the question, how the question can be segregated, and what are the points which are required to write. Once you understand how you divide the questions, you get to know what headings you can make. After that, it is very easy to write the points. If you have read the points well, understood the points well, it is very easy to write the points. Okay, so there are more tests that we have to discuss. So we will discuss the test also in our continuing lectures, next lectures. Okay, see you in the next lecture. Thank you.